just bring it up real fast, is how the determination. Actually, I'll probably be able to get it faster. The actual determination on who has the right to the trust. And that's in the other, one is the Determination Act, and the other one is the regulations. I'm just going to bring it up here fast. Yeah, and that's the regulations one. I'll post the link here, just so you guys can look at it at the same time. There's the link to the actual act, and if you guys are still logged into Omni, you can click this direct link, and I have it in a blog where the important things are in bold. To start off with, we have part 6. I'm not too good at those Roman numerals. The beneficiary includes a person whose favor or whose benefit a discretionary power may be exercised. Now, if we go down and we look at, because this is 47, part 47, and then interest in expectancy means an estate or interest in remainder or reversion or any other future interest, whether vested or contingent, but does not include discretionary interest. Okay, so we can see that a discretionary interest is somebody who's not a true owner, and that's somebody who's actually as a trustee. And we're going to notice that somebody who has a discretionary interest has to have the right of the beneficiaries or the board. Okay, so that's where we're going to get into in this with the board and everything else. You'll notice we'll be coming into that. But vested or contingent, that is when they say that like that, whether it's vested or contingent, that's actually talking about two different types of trusts, right? In English law, whenever there's a vested interest or any type of interest whatsoever, there's what's called in law is a contingency. And that means that if you're not going to do the required action to make it happen, it's not going to happen. So just because you have a vested right doesn't mean it automatically vests. You have to do something in order for it to vest. So contingent and contingency is being used in two different forms here, so you kind of have to keep that always in the forefront of your mind when you're reading this stuff, because when they mix that contingency and vested together, it's because you actually have to do something in order for that to happen. And that's actually what the very next part of this is, where it's determining the beneficial owner of classes of a trust. Now we'll notice that with the writ of entry to decision in the post. Post means in possession. So that's going to be the decisor, the usurper, the abator, all the ones that are actually withholding something after they've had notice of an interest, right? So when they're talking about an interest in possession, it means that you're actually in possession of it, because this act is dealing with two things at the same time. It's dealing with the trustees being able to use these estates on the stock securities and security exchange commissions, right? Security and exchange commissions, right? This is what gives them these acts give them the authority to act as our beneficiary, and that's why those things go on the security and exchange, right? But we do not have the access and the authority through the corporation to act in that capacity. So that's where that control person comes in. And you can't, from what I'm understanding with this act, is you can't actually you can take control of it, but you won't. When you take control of it, you have two choices. You either terminate it and take all the benefit yourself, or it stays in trust to them, and everything that you do with it, you have to do to them. So this is going to kind of make things click with what's happening with Ed Bellinger and these other guys that get only a specific right to the trust, but only further because of they require it to live. And we're going to get into that piece of the act in this as well, because that's kind of where that loophole's falling. But you'll notice
Ed got his. He was accessing his annuities. They were giving him disability, but I'm pretty sure somebody in government marked him off as special person. So if you look at the forms, I think it's Form A1. He would have been marked off as a special person, and that's how he would have been collecting annuities.
Yes, but he's only allowed to collect those annuities for things that he absolutely needs.
Right, which would be disability. They'd only allocate him disability.
Right. That's right. They'll never allow him access to anything else unless he terminates it.
Correct.
So, so as we can see that because this is when you're in reversion, you're actually no longer the corporate person, but you still have those shares, right? Just like in reversion in the land part, it's called reversion because you have a reversionary right to it now. So you're actually not in possession of it, but you actually have the true ownership of it. So that's the injury, right? And that's why decisor and decision are two different things. One is where someone's not actually trying to claim that thing from you, and the other one is where somebody's trying to claim it from you and you're not willing to give it up, right? That actually has a superior interest in it. So that's what this is actually getting at, because if we actually look at interest in expectancy of beneficiaries whose interest can be expressed in terms of a right, right? Because remember, now that we're talking about terms of right, now we're talking about it, more of claim of rights and things that are real actions in equity. Because we got to remember, equity is the only one that has real, personal, and mixed jurisdictions. Common law is only real, and it's a corporeal hereditament in the real jurisdiction. And in equity, these are all incorporeal. So this is this right that they're talking about. The reason why they always just use a right is because then this will work with any jurisdiction and any capacity that you're in. Because it depends on your capacity, and the jurisdiction that you're in is going to depend on what right you have to the thing in question, and how that, whether it's an equitable right, which is just a simple just a right to possession, or the double right with ownership and possession, which also includes the fee. So it gets even more interesting because they talk about the percentage. The very first one is a certain amount of percentage of any or all, any part of the income of the trust, right? And then we go to the capital of the trust. So you'll notice that in equity, it's always a capital because it's only an equitable use, so it can't be the real thing, because this is talking about what the capital is to the income of the trust, right? Income of the trust is number 2, and the capital of the trust is number 5, right? So we'll see. So we notice that they're already telling you the next question down on what the interest of the trust is, right, and the capital of the trust, right? And we're in a Canadian Ownership Determination Act, so we know that we're talking about shares, because that's right, a share in a corporation. So we can see that by these two, by number 47 and number 48, it shows that you have your interest in expectancy. So this is what gives you the right to file an application. This act is not for terminating. Well, I guess you could terminate it, but this act is mostly about who has the right to apply to the minister to see if they're an eligible person to the trust, and to get a certificate on who the control person is, and if they are the one that holds the future interest, whether vested or contingent, can determine whether or not they want to vest it, keep it there, or just make themselves just the control person of it. Kind of see what I'm getting at? So this one part here is the part that gives you the right to send this application to the minister for determination, because all he has to determine is whether or not you're an eligible person. As soon as he determines whether you're an eligible person, now the next thing is who's the control person, right? Once you've gotten determination that you are the control person, now you can determine what you want to do with this asset yourself, because you are the actual owner of it. Okay, and if we go now, here's the numbers 40, section 48. If we go down to D, this is where it gets into the discretionary power. So this if you're not the control person, you're only got discretionary power, and this is where the thing with I guess Ed Bellinger and the other guys that are getting only specific set-offs for certain things. And we can see that the Canadian ownership rate of trust shall be determined without regard to the existence of any discretionary power to consume, advance, appropriate, encroach upon, or otherwise dispose of all or part of the capital or income of the trust, or to or for the benefit of any one or more individuals who have an interest in the capital or income. Right, because that's two different things, and they're stated above. Independently of the existence of the discretionary power. See, so it has to be an independent, right? It has to be independent from the existence. So you have to be the true owner of it. Otherwise, if the exercise of the power is limited by a determinable standard relating to health, education, maintenance, support, or comfort of such individuals or individuals. See, that's the what would you call that? It's the opposite to the rule, the exemption, right? That if the exercise of that power is limited by a determinable standard, right? And we already know that municipal law is a determinable standard to limit your power, right? Because that's right, and it also gets into that into the control with the eligible person and being the eligible person, but yet not the control person. And then the rest of this pretty much goes more into the rest of the stuff. But you'll notice that even that one, if we go back to D, you'll realize that once you have that ultimate power, you can now consume, advance, appropriate, encroach upon, or otherwise dispose of all or part of the capital or income of the trust, right? To or for the benefit of any one or more individuals who have interest in that capital or income, right? What else? A lot of this blue stuff is pretty good, but I want to get more into the actual. You guys can still hear me good?
Yeah, keep on going.
I just got to pull out my PDF now.
So what's unique is if you look at the forms that you got there last year, or is it 2 years ago now? I'm confused. Anyways, in the forms there, you don't even have to fill out the forms. You can write it all in your own letter as long as it has the determining information that they require, or that the minister requires, I should say.
Okay, so what did Tyler Cummings do wrong?
Well, he started talking to you.
No. He failed to determine it. And I failed to
But you didn't have all the determining factors though from those forms if you look at it. Right? Because you guys were basically thrown together and he kind of knew what was going on, but you didn't, and you had just enough information that he was hesitant. So to me, it looked like you guys met and not meant to meet.
Okay, in the PDF, if you scroll down to page 6, Canadian ownership rate and control status determination. Every application for a certificate shall be filed in the prescribed form and manner and shall contain or be accompanied by the prescribed information and documents. And
Hey, William, what number is that in the PDF?
Yeah.
Page 6.
Okay.
Okay, just let's get it there. Is that in the middle, bottom, or top?
Very top, number 5, application.
Oh, okay, gotcha. Yeah.
Yeah, we're on the same page now.
So let me mute this here.
Are you guys all there? Let her scream, Angela.
I'm in control.
Yeah, we're
I'm in control today.
I'm going to put my mic on mute though. That's what I'm. Okay.
So every application for a certificate shall be filed in the prescribed form and manner and shall contain or be accompanied by the prescribed information and documentation. So it does not have to be on the form.
No, that's what I was saying. You could write it in your own letter as long as it's having the prescribed information, the relevant information, which you didn't have.
No, I did.
Did you think you did?
I know I did. The only thing that I did not specifically do is specifically ask for a determination on my eligibility and on the control person. But
so then you didn't have the prescribed information. So that's what I'm saying is you guys met and.
Okay, but hold on a second, Justin. The reason why, yes, if I would have had the exact wording, it probably would have went right through. But what I'm trying to get at though is that in English law, you don't have to be exact. It's not up to you to be. It's not up to.
I get that, but if Tyler was usurping that position and it was nobody's been contacting him, and all of a sudden you popped up, right? And then he started talking to you.
But remember, I didn't contact Tyler. I contacted the Minister of Natural Resources Canada, Stephen Carr himself. And he's the one that gave it directly to the Director of Natural Resources. Right? and not until I emailed Stephen Carr back and told him this guy's, right, he's playing a game. He's not following instructions. He's wanted to get into phone call conversations and everything else and not deal with the determining factors, right? You see what I'm getting at? And then the next time I tried, he was gone from his office, right? Because I was.
Yeah, he was sick. He took sick leave.
He's still sick leave, isn't he?
I don't know.
He's not back in the office. It's now a woman in his office.
Yeah, I don't know what's happening there. So
from my understanding is because he actually broke a lot of the acts. Okay, well it'll be much easier if we discuss this after. The next part is control status right below that. Subject to any regulations under paragraph 20. A person is Canadian controlled if that person is a non-eligible person, is not a non-eligible person, and is not Canadian controlled if that person is non-eligible person. Right? So they can't control you if you're not a Canadian citizen. Because are you guys familiar with what they're calling a Canadian controlled person, a non-eligible person? Page 2 on the PDF. Definition of non-eligible person. And if you notice, they don't even give you the actual definition to the non-eligible person. They make you go to Chapter 46 of the Statutes of Canada, 1973-74, in the Foreign Investment Review Act, subsection 3, number 1. So that is not in any CanLII or anything else. You have to go to the Canada Gazette to get it. Well, I did it.
I was gonna say, I've searched everywhere for days to try to get that, and you just had it. It was beautiful.
And that's what's in the green. Everything that's in the green is from that Chapter 46 of Statutes of Canada, 1973-74. They're also on Omnipotence for you to download, including the forms.
Awesome.
The forms are also in the Gazette in a completely different place, so none of this stuff is actually online for you to get there. They stick them all in. All the important stuff is in the Gazettes. So, a non-eligible person is neither a Canadian citizen nor a landed immigrant. A non-eligible person, remember, right, is an individual who is neither a Canadian citizen nor a landed immigrant. Right? A Canadian citizen who is not ordinarily a resident in Canada, right, and who is a member of a class of persons prescribed by regulation of the purposes of this definition. Remember the class of persons? Class of persons is what? It means that you're bound by the common law and you're a corporation. Landed immigrants who have been ordinarily resident in Canada for more than 1 year after the time of which he first became eligible to apply for Canadian citizenship. So the rest of that's kind of boring, but that's basically basically telling you that if you have never had a Canadian citizenship, you are not an eligible person. If we go down to the next page, presumptions as to non-eligible persons. This is where it gets really good. Now, if you notice how now they're actually putting the presumptions right into the actual act, but they didn't write them into the actual act of legislation. You got to realize that this is not an act of legislation. This is, if you notice, there's two different governments in all governments. There's an elected government, and then there's an appointed government. The appointed government makes this stuff, and the elected government makes the laws that are granted from this stuff, and they must comply with this or they're of no force or effect. Well, in reality, this isn't any force or effect either, because the common law is the true de facto law. But anyway, the presumptions as to non-eligible persons, right, where in the case of a corporation incorporated in Canada, right, now we're just going to jump down to, because the other one is more, because corporations because Canada has actual corporations like the Bank of Canada and so on and so forth. Those are made up of a group of people that chose to make an incorporation inside Canada, so that's why it mixes between the percentages and everything else and your voting rights and so on and so forth. But that's also what determines whether or not you have the full 100% in order to be the true control person for your own individually named trust, right? So if we go to if we go down to the second part of number 2, that they're owned by one or more individuals described, right, of the definition non-eligible person. So that's why I put that there, so that people, so you can see that the ones that are talking about 25%, 40%, stuff like that, means that this is actually a corporation created by a bunch of people, so you're not actually talking about your individual trust. Shares of a corporation, right, are owned by one. I should read that whole one. Shares of a corporation to which, this is number B, the shares of the corporation to which are attached 5% or more of the voting rights ordinarily exercisable at meetings of shareholders of the corporations are owned by any one individual described in the paragraph A of the definition non-eligible person in subsection 1. So that's basically saying that because you're doing that, you're actually a part of a non-eligible person because you're part of the corporation, and you can't be a control person because you don't own 100% of the shares, right? You'll only have a 25%, a 40%, right? That type of thing. Only once you have in equity, only once you have a certain amount of control can you actually take full control and do whatever you want, and that requires 100% in order to take a corporation and dissolve it and keep all the money to yourself. The next one is acquisition of control, right? Control of a Canadian business enterprise may only be acquired in the case of a Canadian business enterprise that is a Canadian business carried on by a corporation either alone or jointly, or in concert with one or more other persons. So they're basically trying to tell you right now that the control status within equity is always done with more than one person because it's a trust, and trusts are always done between two or more people or corporations, which is a law which was created in the Law of Property 1925, where all trusts have to be two or more people or a corporation created for that trust. And that's what juristic units are. They are a corporation created to manage the land trust. The acquisition of all or substantially all the property used in carrying on the business in Canada, right? And in the case of other Canadian businesses, right, by the acquisition of all or substantially all the property. So we can see that they're already getting into where you have to have full control. The rest of that is more talking about getting acquisition of shares and stuff in the ordinary course of business, which we're not really concerned about, but it's good information to actually kind of look at. If we go to the next page, page 4, A, 4 lines from the top, there is in effect an agreement or arrangement enforceable according to the terms thereof, under which upon the satisfaction of a condition or the happening of an event that is reasonable to expect will be satisfied or will happen, the corporation will cease to be controlled by the controller and be controlled by the person or group of persons which whom or with each of their members of which, as the case may be, the controller is dealing at arm's length, right? So that's really the punchline right there, right? So we already know that that everything that is in your name that you didn't sign is an indenture for you. We know that we have 2 different indentures for 2 different trusts. One is your shares for a corporation, and one is your shares are in the land. So, because they can't control the land, because they don't own it, they can't determine who gets how much of what. But they do own the corporation, and they made this agreement that everybody agreed to. So they've already determined that everybody gets 12.8% of all the natural resources of the planet. I mean that this juristic unit sucks from our inheritance in the land and waste. So we can already see that It's the actual control person that takes that makes the right to vest, right? Because once that condition or the happening of the event that is reasonable to expect that will be satisfied or will happen. So what are we talking about here? We've got two trusts, right? And in order to vest your estate reversion, you have to remove your estate of possession and move into remainder. So isn't this basically saying, without actually saying it to people that don't know, that you have to show that you actually are going to be vesting your whole estate, because they're not going to let you be a remainder man and be the control person of the shares, because you're no longer a part of that. Kind of see what I'm getting at? So this, to me, is basically saying that you have to show that you're vesting your estate, that you want to close your estate, right? And that they don't have any choice about it, right? And that's why it's these things that, and there's more of them yet that we can actually deal with this to show the extent that it's the control person, and all we have to do is basically go to them and tell them, "Nuh-uh, I'm sorry, but I want no part of this, and I know that it's the acceptance to the land tenure, and I know that I can't do this halfway, and I have to do it all the way, and that means that this condition or the happening of an event is more than reasonable, and it's gonna happen with or without your permission, right? So then that means that now they are no longer the controller, right? Number one, cease to be controlled by that controller. Number two, now it becomes controlled by that person, right? And the rest is all about somebody who's taking it in trust for another, right? By a person or group of persons with whom or with each of these members, of which, as the case may be, the controller is dealing at arm's length, because that's what it's required. Your trustee has to be at arm's length in equity, right? So all the rest of that is just to do with the rest of the act, because this act is written in two forms. This is written so the donor can vest, and it's also written so Canada's the ones that are appointed by law have the law to control your assets by a group and still being at arm's length and have all this other stuff to guide them, right? Because that's what all this other bullshit is about, is because now when you're in that kind of position, now they're only in a 5%, 20%, 50% type of position, because there is no true owner and everything's in a group situation. So now the shares are, right? Like, if it takes 50 people to buy 100 shares to make up the complete shares of Walmart, right? As those shares get mixed around and everything else, those percentages change, and the power of those people within that company change, right? But as soon as, now let's say I gave all those 10 people 100 shares each to begin with in trust, where they have to give it back to me in a later date when I ask them. It doesn't matter how they move them around inside each other. When I come back and tell them that I want it, all those people have lost all their authority, and all those percentages mean nothing, right? And that's all that they're doing here to mix everybody up. They keep putting both jurisdictions in one, right? It's even in the law of property. It's in the law of conveyancing, Landlord and Tenant Act, Commercial Tenancies Act, right? These are all the acts where our reversionary right with the future expectancy, right? With a vested or a contingent right, allows you to circumvent the act, because that's the words that they use when one of their presumptions cannot perform because you've refuted it. So it's really it gets really interesting the way that they're writing these things, and once we can see how they write two things in one sentence, it's unbelievable. And now we need to go back down to page 6 again for that presumptions and control status, Canadian ownership rate and control status determination, where we talked about where we were talking about the application. We'll go back to that now because we had to go over that non-eligible person that came up in this just to make sure. So their presumptions are basically with two different things, with respect to a partnership and with respect to a trust. So and one creates the other. So B is actually A and A is actually B, because with respect to the trust, you have to create this trust before the partnership arises. So because they've made this assumption, they've reversed it, right? So if we start with B first and then go to A after, it'll make more sense. So with respect to a trust, the beneficial interest in the property, right, of the trust shall be deemed to be shares of the corporation. The owners of those beneficial interests shall be deemed to be shareholders of the corporation, and the trustees shall be deemed to be members of the board of directors of that corporation. Okay, so we already know who the board of directors are of the corporation because they're the unelected members of Canada. Now, as you can see, now you're made into a beneficiary, and that your shares are to be deemed to be shares of that corporation. Right? Now this is getting really interesting. So when we look at A now, with respect to a partnership, because now they made us into a partnership, right? Because they decided to take this trust and make them a part of the shares of the corporation and make you the beneficiary. So now we're actually in a partnership, right? That the interest or rights in respect of its capital or income, see now we're at the capital income because it's in a trust, right? So it's not yours, shall be determined to be shares of the corporation. So now they're putting it back into the shares of the corporation because you can't have access to it because you're not the control person and you're not falling within needing it for your actual benefit to live, right? The beneficial owners of those interests or rights shall be deemed shareholders of the corporation with respect to a limited partnership. So now did they not only make you a part of the corporation, they made you into limited partnership. So they even put you another arm's distance away because a limited partnership is not the corporation. It's a corporation inside a corporation. Any general partner shall be deemed to be a member of the board of directors of the corporation and with respect to the press. Right? See what I'm getting at? See how they flipped it around? So then you're actually thinking it's something different?
Yeah, good find.
Right? So now the next one is where it gets even better. The determination by the minister under the Foreign Investment Reviews Act. So, where the minister designated to the act as the minister for the purpose of foreign investment, so that's the Minister of Natural Resources, he has reached the opinion that a person is non-eligible person within the meaning of this act. The person shall, subject to the regulations, be deemed to be Canadian controlled for the purpose for as long as the opinion is binding on the minister. So this just leaves it completely open right off the hop for him to just make an assumption about the non-eligible person. Right? So he can, without properly dealing with the non-eligible person, you can't get to the control person. See what I'm getting at?
Say that again.
If you can't make the minister, if you can't prove to the minister that you are the eligible person, right? he automatically
Okay.
assumes that you're the non-eligible person.
Mm.
All right? Because that's what this whole act is saying, that you're that you are the non-eligible person because you're a corporation and you gave your control status. Because don't forget, non-eligible is a twofold question. Right? Do you have shares in the company, and do you have the right to come and ask us about them? Right? If you're not the control person and you don't know that you have a future interest in it, you have no right to ask the question. So if all those people that try to call up the minister, and if they don't actually tell the minister that they have a future right in it, in a reversionary interest, right, you're automatically booted. And that's why this is why I think I got sent directly to Tyler Cummins, because he was supposed to sign the fucking check. Right? Because I already proved that this was going to end up happening either way. Right? You see what I'm getting at? So basically Tyler Cummins played the word game on me, and it got him removed from office because he blatantly.
So he was supposed to hand it, like you said, sign the check, hand over the annuities.
That's right. Make the determination that I was the eligible person, right? And now I'm the control person. And once I'm the control person, they can't tell me if I can close the shares or tell them to pass the accounts and right.
Yeah, that's what I was trying to express, because he wanted to talk to you. So I don't think he had experienced it before. Either he's just been in the position long enough, nobody's come up and done this, or he just didn't know. That's why he wanted to talk to you.
And that's why I think he got removed, because he totally botched it. Because he wanted to call me and get onto the phone and talk about things, and it was like, there's nothing to talk about. Right? That was my opinion. There's nothing to talk about, Matt. Right? Now this idem, the next one down, gets even better. Okay? Once he has reached the opinion under subsection that the person is non-eligible person within the meaning of the act, or demands notice. Okay? Now here's another, here's or. Right? It's that or. Or demands notice under section 8.3 of that act from a person he believes to be non-eligible, that person shall, subject to subsection 3 of this section, be deemed not to be Canadian controlled for the purpose of this act, for as long as the opinion under subsection 4.1 of this act is binding on the minister, or the demand for notice under subsection 8.3 of the Act is binding on the recipient of the notice, and any certificate issued in respect of that person shall, if necessarily, be revised accordingly. That's the punchline. You guys got that? Read it again real slow after the or.
Yeah, it's basically saying that the minister needs to not assume that he's non-eligible, isn't it? He's saying that you need to revise yourself and actually make the correct determination on this.
As long as the individual demands under subsection 8.3, right? And then there's another part, because remember, this is every time you see an or, an and, they're talking about something else. So at the very first one, he says, right, where he has reached the opinion under subsection 4.1 of the Act that the person is non-eligible, right, or, right, within the meeting, or the demand, right, right, because that's us, right, making a notice under subsection 8.3 of the Act from a person he believes to be non-eligible, right, that he believes to be non-eligible. That person is now deemed not to be Canadian controlled. Right?
So
Mhm.
our notice going in is what switches the capacity.
Exactly, our choice, right? It's that contingency. We have to do something because there's no English law fairy that can read our mind and go and make claim for us.
So you didn't spell it out to Tyler. He wanted to talk to you, which would have smoothed things out, but nonetheless, that's basically what happened. So he got punished, and you did too because you don't have your.
Well,
You don't have it.
that dealing with all the time dealing with the government, talking to them on the phone and getting personal ain't smoothing things out. They're not there to help you. They're there to bend you over and fuck you from left, right to sideways. Like, they're not right. Like, they're not there to help us. Dude.
No, I get that, but if you would have told Tyler or basically demanded that he determine it right there, and that would have ended it. You just
Exactly, because I didn't have the exact words that he needed that he wanted written across the page, right? But the whole point that everything in this act is saying that once we've proved that we have that vested right and we are vesting it, they are fucking done. They have to give you the determination, right? And when they don't give you the determination, you take it to the Queen's bench. I think this is the federal. So you'd be taking it to, you'd be mailing it in for your $25. I think that's what the federal court case is. You mail it in and it's $25. Because it's pretty much all done by summary judgment. So, and then in the next it goes into the application for the application and certificates. Right, and the that you've been informed, the determination that the minister has to make, the issue of certificate, right? But there is going to be no certificate reissued. It's going to be a passing of the accounts and closing of the accounts, right? So they're just looking at it as issue a certificate because most people, the government uses this. So let's say Tyler Cummins was the one in charge of everybody's estate in Canada. When they remove him from his position, they have to have a law to be able to give it to the next person. So that's what they're using this for on the flip side. Right, so they're using all this stuff in two different ways. They're using it as an internal accounting, and then it's also your remedy for that trust, right? So between the Municipal Act and this, it's pretty much right. Tells you exactly how the government gets you. The Municipal Act is the actual land, and this is you for your corporate person, the acceptance.
So they wouldn't do a release or confirmation if we're not the control person.
Probably not, because then, right? Well, actually, if you see that's kind of tricky because English law, if you don't make the claim, you don't get it. So the way that I see this is that, let's say you didn't know about this, and you went and you terminated it, and you vested your lands, and you didn't even know about it at all.
They'd just keep the shares, wouldn't they?
They would keep the shares, yeah.
I thought you said though we could use the writ of waste to go after that.
The writ of waste is for the waste from the lands.
So then this is good that we've come across this because we would have basically, we would have missed ourselves out of the millions.
Yeah.
Which is maybe what I did.
Well, no, you still have that.
You're in charge. You're in charge of them. They're just not giving them to you.
Fuck, yeah, it is. But as you might
All he has to do is ask. If he rings them up and says, I'm
A
vesting.
minister, not ask. A minister.
No, I
Yeah,
think Ez might be
minister,
the
not
control
admin.
right now. Ez, didn't you give your control to the government for that?
Give my control.
Remember you?
No,
Remember you did something?
Yeah,
I
I
have a
handed in
letter-
all the deed polls.
Yeah.
I handed in the deed poll and endorsed it over, but it's in a private account in a vault.
Exactly.
And they gave me back a letter saying that I had control of the account as the executor.
There you go. You're the control person. You have to find this
Wow.
act. You have to find this act. That is like, they weren't allowed to do that.
Ez can pay for everyone's vesting fee. Woo!
Yeah.
Yeah, if you tried to do this post 2012, they would have just OPCA'd you, but they didn't know what to do before.
Yeah. That's exactly it.
You're in a good position right now.
Fuck, you could be in a really good position.
Whatever your
Well, I know
age
they have
is.
notice of everything because they take away debts and everything else when I send in any letters for any kind of validations and stuff that I used to do before. And I've sent it to enough of the high-level guys, but it's only in that state, so, I don't know.
That's right, because it's only that state that holds it.
So this
Yeah.
might be what the position Anna got into then is the control person.
Yeah, but that's the
You
thing.
may be right.
But the control person is not freedom.
Oh, no, it's not. Well, it depends on what you define freedom, right?
Well, that's what equitable freedom or true freedom. You got to remember that this is just fake. So tomorrow they can go write a different law, and now you get no corporate stuff at all because it's theirs, right? Whatever they decide to create in this fictional realm of the incorporeal is completely fiction. It's the Matrix. Like, even the value that we're getting from this corporate trust, once everybody realizes what English dollars are, you won't be able to fucking give them away.
No, this is what's going to demonetize the Canadian, the American dollar, all of it, English.
Yeah, the English dollar, period. Once people realize that dollars
We'll
are
be
slave notes,
responsible.
right? Dollars are slave notes because everybody that uses dollars gave their lands away.
So then within
Rip.
3 days we can have this, we can become control persons then.
I think so. Yes, we just have to write this up and in a really well way. And I think because fucking all the hassles that I give them, as soon as this goes across Stephen Carr's desk, it's done.
Soon as we send our notices, though, if we're control persons, then we can take our children then though too.
No,
Why not?
you have to be two or more.
That's what I'm saying. If we're both in the control person position, then we can take our children.
No, you can't take the children. You're taking the trust.
Well, yeah, that's what I meant. I'm sorry.
So, but then that's the thing. All the stuff that you have to show, it's easy to show. You just have to show that it's not for their best interest, right? And all these things, and that you're just gonna. It's good. Yeah, it's a little bit more complicated than just doing it for yourself. But yeah, as long as you're showing it that it's, as they say, as long as you can show that it's for their actual true benefit, there's nothing that they can do. So. And that's what all
I got a question for you. How can you, you said there's two sides of this, right? There's the corporate control part of it and the land control part of it. Now, there's no rules for the land control part of it, and there's a lot of rules for the corporate control part of it. So if you're the control person, once you're out, where is the way of how are you going to start making your own set of rules?
Okay, I gotta correct you because everything that you said there is actually wrong.
Okay.
The land part, it is there. It's in both equity and common law. How they write it in equity is with it's going to be stated as a reversionary interest or a future interest, right? Or a vested interest, right? All those three things mean the exact same thing, and you'll find that in the equity law, which is law of property, law of conveyance, Landlord and Tenants Act. What else? There's a bunch of them. I have a list of them. A bunch of them are already on Omni. There's two different worlds here. There's two different trusts. There's the land trust, and the only thing that you get with the land trust is the land and the waste that's done to those lands that you claim. The corporation, the incorporeal jurisdiction, that is only you only get what you can create things. You only get the equitable interest from the things that you have a use for a fee for. So if you buy a house and if you buy a house for $20,000 and you get $100,000, that 80 grand is yours, right? See what I'm getting at? You can't take the house when you leave. And because you're a corporate person, there's certain stipulations where they're going to tax you on certain things and all that other stuff for that, right? But once all those agreements are taken care of, that leftover goose egg of fictional fiat currency is all you can take. So that's what those corporate shares are establishing, is the 12.8% waste from all the corporate people in Canada, because we all joined into a group together. So the incorporeal hereditament is one group in law. So they're one group in trust. So all the waste within all the common law jurisdictions are grouped into one, right? And then we have the the corporations where it's broken into little pieces of pie, right? So common law is the pie. Every government is a piece of pie, right? That's why the consolidated revenue fund is the pie, right? And every piece of pie with inside it has to pay to it, and when they need to take from it, they take from it, because that's what it's there for. It's for the entire common law group, right? Everyone within the United Nations has these rights. Just some of the countries don't really understand what all this is really about even, right? So, and that's kind of the issue with equity in these corporations. It's because now all these corporations have to make agreements between themselves to make the best deal that they can to get the best, the biggest pipe, I guess, to stick up the Canadian ownership determination's butt to get as much money out of it as can, right? So the bigger countries have more power and everything over these other countries, so they get a bigger pipe, right? And that's really what all's equity is. It's just a battle over the fictional money that they can create from all the natural resources. So the more natural resources that they actually waste, the more money they can make. But the catch is that everybody actually gets 100% of that natural resources if they didn't give it away, right? You got to remember that there's the 4 levels of trust: A, B, C, and D, right? B, C, and D all take a share for managing that trust, right? So that's also why when we're looking at it, that Canada can only give 12.8%, right? Because, well, they got to pay Canada, right? There's two levels of trustees in Canada: the elected government and then the non-elected government, right? Then you have the UN, right? Because you got to remember they made United another jurisdiction inside for these corporations, right? Which is the law of nations, right? And then you have the monarchy, right? So all these services and benefits that are in the incorporeal hereditament require that waste to live, and it's not. And the governments, and you'll notice that there's no governments that have rock quarries or anything else. Matter of fact, most governments only do maintenance. Most governments don't build roads, right? They contract that out. They contract all the waste and damage to the lands, right? There's no government logging companies, right? You see what I'm getting at? It's all up to the fee simple citizen that volunteers to injure their inheritance, to go and cut down these things and break the lawful agreement, right? And join a legal agreement and make that acceptable to do. right? And that's why if people actually look at the very beginning statutes and stuff, like around the Statute of Westminster the First, even baking bread, cutting the wheat, planting seeds, growing gardens, they had to write laws to allow the citizens to do these things because it wasn't theirs to do it with anymore. So that's where all this stuff really, really comes in, and it's all just fake, like all this money, and that's why, like, why else would they? A friend of mine looked into this Canadian Ownership Determination Act, and he says by the time you're 40, you're going to have over $40 million. Okay, well, let's look at even today, right? $40 million. If you had $40 million at the age of 40, would you ever be able to spend it all? Why would they give you such a ridiculous amount of money? Right? And then we look at this. Now let's look at how the system is, and the donor that isn't supposed to have any money. Right? So if you were in the corporation and already injured yourself, they give you $40 million. But if you've never been in the corporation, you don't have any money. So in order to get anything from any of the fee simple, you'd have to write a writ of waste to get it. Right? You see where I'm going at with this? But you've already been scammed. Right? So now they give you $40 million. Right? So you don't have to write a writ of waste. If you want that Ferrari or you want that cow or whatever else, you're just going to go buy it because you're not going to go through the 2 months of court bullshit to get it.
I'm listening to it.
Again, they've designed the law perfectly for the donor, it appears.
And to hide their travesties. So right? So we don't end up coming back into that system after and causing waves. They're going to give you so much money and your own lands and everything else, to just say, okay, go away and please don't tell anybody, right? We're going to make it so you're not going to have any more worries ever, right? But that's why does just the point of that, just anybody that wants to actually step back and just think about just who gives something like that, right? The only people that give something like that are the ones that have been raping you for so long that they don't want their head on a noose. You kind of see what I'm getting at? So even though we did it to ourselves, right? Just like everybody on Facebook and everything else, well, there is no contract, blah, blah, blah. Well, they hid it, right? And everything else. And they made an illegal law to justify it. And the only reason why that they can justify it is because everybody in that territory believes the lie. And, right? You see what I'm getting at? So it's because the people around us that believe the lie. It's not the judges. The judges would definitely let this stuff be flying right away. But how? You got to remember the people outside, right? Like, could you imagine if they televised one of these trials? Like, if something like this, right, got televised to the people where some guy was wanting his lands and we were claiming it from him, and they showed all this stuff, and the Canadian Ownership Determination Act just showed it all to everybody, that'd be it, man. As soon as you walked out of the courthouse, you wouldn't have a property. You wouldn't be able to get home.
This is the Achilles heel of Fee Simple. Yeah.
Exactly.
Once like the first case, like you're saying, becomes even just, it'll be viral. People pick up on it, and that'll be it.
Well, that's why that's why they set up equity so they can't hear or determine it, and that's why.
Right, and if you're not that control person, then you could go into common law and stumble still, not even realizing it.
That's right, but the biggest factor is that everybody in fee simple will never be able to see it unless the government decides to show a court case and actually show it, but they can't.
But technically, though, if you sit and think about it, by you being in the capacity of the control person, you allow yourself to see through the lie. That's the only capacity where equity is allowed to see it all, is the control person.
That's right.
Because the control person would be of capacity.
That's right.
They have to be.
That's right. They're the one that's in control of it, not them anymore. And that's what they're using for their authority, that agreement, and that they control it. Well, not only is there no more agreement anymore, but I control it as well.
So wait, if you look at the Bank Act 93.3 in the Bank Act there, that's something I first found when I looked into law. Right there, it says the process of law in there, and I'm almost damn certain that that's going to be the relationship that you have with the banks post control person capacity. It's written right in there, 93.3.
Yeah, and the banks are also linked to the Canadian Ownership Determination Act. Same with all the life insurance companies and everything. Those are the control people to our Security and Exchange Commission.
So he's still going to have to issue a certificate even if we close off everything, because that's how you're going to communicate with the bank. Because there's going to be no other operation in law that they're going to be able to have as a control person. Like, what would it be? If you had a certificate from the natural resource minister saying that you're certifying that you're the control person, then you would be able to use 93.3 of the Bank Act, where everybody's trying to fight and use the Bank of Canada Act.
No, that's why they make a private act.
Okay, but that's still that's still what that operation of law that they're talking about in there. I'd have to look it up and read it.
See, from what my understanding is, because they have to exempt you from that jurisdiction, all those laws don't apply to you. They only apply to those people. So the only way that they can give you that right to go to that jurisdiction is if you write your private act to give you that authority.
I've got that 93.3 here if you want to hear it, Justin, if it's the right one. It's the permissible registered holder. If a person on whom the ownership of a security of a bank devolves by operation of law, other than a person described in subsection 2, provides proof of that person's authority to exercise rights or privileges in respect of a security of the bank that is not registered in the person's name, the bank shall, subject to this act, treat that person as entitled to exercise those rights and privileges.
Yes, if it's not attached to the bank. That's the catch. Because you're the corporate person, they are the control person. Right,
but you being a control person, though, you're going to be able to use this operation of law that the bank's usurping from us.
Yes, how I understand it is that this Canadian Ownership Determination Act takes all your RRSPs, all your bank accounts, everything that's all your equitable interest in things that are in deed polls and whatever else. They do this accounting, which is in the Act. The entire accounting is in there. Everything. The entire formula and everything.
Can I interrupt? It's called tracing. It's not accounting, it's tracing is the correct term.
Okay. And then they take all that information, and they have to open up a new account for you in a private international jurisdiction. Because the Bank of Canada is a bank for the, right? And the banks within Canada are municipal banks. For that jurisdiction, they've gotten a grant from that jurisdiction to carry on business in that way, right? So
then 93, then that's simply if you wanted to be a control person and stay in equity and float around and play. That's basically what that's allowing them to do then right there.
Sounds like it, yeah.
Yeah, that's so the minister can say, well, when you, instead of every time you needing to pay for a prescription, instead of you having to call me, right, I'm just going to write you this exemption, and then you can just go take it into any bank you want, and they'll just pay for it out of that account.
Okay, right. So that's okay, yeah.
And that's pretty much sounds what we hear that's happening too. Right? They only get specific things that they can go and set off for.
Well, that's how they would be paying for Ed. That's I think it's Form A1, where they mark you down as a special person. Yeah, right here, special person. So then that's what they would be doing. So whoever's being the trustee for like Ed's annuities, they'd always be paying out disability each month using that process right there.
And that account number.
Yeah. Sneaky.
Right? Because it all has to be accounted because it's all going against the estate and the waste. Right? Because he's got the corporate estate and he's got a natural estate. The two are always playing in concert together. Everything that they pay, everything that everything that I get from a benefit from the incorporeal hereditament, I'm actually only getting a fraction of that benefit. Because if I was standing as A, I would have whole 100% of that, right? But because it's got everything that gets created every time everybody makes a purchase and exchanges something between each other, the government is taking a percentage for the donor, for the monarchy, for the international law community, right? And then for that jurisdiction that you're in, for that government, and then to you, right? So the reason why nobody can see this is because they've never seen the 100%, right? And that's why that's why bread is going to be $5 a loaf right away. And that's why they keep manipulating the money the way they are. Nothing has ever changed, right? We're just getting smarter and everything else and getting more free time to learn the truth, so they got to make it so everything costs us. Like, you got to remember that the industrial era of the 1900s was pushed through so people didn't have to work so much. We've never worked so much in our life. Like, in the entire history of mankind. Not even as slaves in the time of Egypt did we work this much. Even then, I think they only made you work 4 or 5 hours a day. So, like, it's when we really start getting into the nitty gritty on this stuff. It's really very simple because all they do, it's just a trust inside of a trust. So whenever we're talking about the corporate person, we already know that only thing that we're ever talking about is just the equitable interest to the things that we did hold. Right? That's all that we can take with us as a bank account.
So what do you think that it was that triggered for your information included? Obviously, you missed saying to determine trust, right? But just let me read this. In the Canadian Gazette, it says here in number 3, this is the instructions for us in Canada, SOR/DORS/85-846, where any provision of this order provides for the making of an application in a particular form. So they're talking about those forms of theirs. Yeah. The application may be made in the form or in the form of a letter or other appropriate form, but in any case, the application shall include the information indicated in the form. What form, like, I'm reading over it, and it doesn't really clearly state anything other than the name is what they'd basically be looking at, because, or unless you use the partnership capacity, like, what do you think triggered that? Other than you just revoking your consent and showing that you ceased to be controlled by their controller. Is it just that it?
I don't understand what you're asking me.
Why did he send you to Tyler? So in other words, the Minister of Natural Resources, he had the opinion that you were there. Right, so he gave you to the director, but what did you send to him specifically that would have been required?
That I was vesting my estate.
Right, so basically that you're just not being seized by the controller, which is in the Foreign Investment Act, isn't it? Let me grab it here.
No, basically what I did, well, that's the thing, because
yeah, number right here under A.
Because you got to remember, at that time, we actually thought that the government could hold things in trust for us. So So without actually, because I didn't get into into the nitty gritty about anything, because it was like, well, why would I have to? Right? Here's the forms. Throwing on me.
Yeah, I got them all printed off too. What's crazy is that we've had this for what, like 2 years or 1 year? I'm not sure now if the year changed.
Yeah,
calculate that. Actually,
no, it won't be quite a year. Because I actually went, July last year is when I...
No, it was in 2016.
Was it in 16?
Yeah, it's 2 years. It's going on 2 years now. It had to be in 2016. There's no way that just happened last year.
No, I'd have known about it. I come on the scene last year, didn't I? About May last year.
Yeah, I've had these printed for a long time.
Is this all
right here? Yeah, right here. October 21st, 2016 is when I printed it.
Okay. So then, yeah, it would have been July of
2016
that I started that. Yeah.
Wow.
But I haven't really gone back to it then since, right? I just kind of been...
No, it's funny how we've come back to it to realize that without being a control person, that's going to really handicap us. Like,
this could pay for everything we need to do.
That, to me, that's the seat in law that you have to be in order for the other guy, right, the judge, in order for him to see somebody that can transgress the two jurisdictions, right? Because when you put that suit on, I guess you want to call it, then you can enter both dimensions. You can't in any other capacity.
You know, that's what the executor is. The executor can move between life and death.
Yeah, I guess. Yeah, I guess you kind of like.
So then you are the control person. You can end this.
I can. Yeah. Well, I'm the control person, but we have to. That's the thing. We have to make it so the minister must do it.
Yeah, it has to be of his opinion because it has to bind onto him.
That's right. And and I'm sure that's why he got rid of Tyler, because it basically going to fall onto him.
Well, it had to fall on him.
Yeah.
They weren't doing anything prescribed under law. So equity would have had to shit down on him.
Yeah, exactly.
Yeah, you know, it's funny because when they got rid of the person that gave me my stuff, I realized what they're doing. They're getting rid of that person because then all the people above her or him are responsible. So they got to get rid of them.
Ignorance of the law is no excuse. That's what's stopping them, so they get rid of them.
When I mean fired and get rid of, all that means is they take them out of that seat of office and throw them in another jurisdiction.
Yeah, they don't fire them. They just
they don't fire them. Like, they just move them around. But that's the same thing. Because now now that we're learning what jurisdictions are, and this is why we named the seat, not the person in law, right? We name the actual position, not the person. Right?
See, what's funny is a little backstory on Ed is he's in discussion and length talked to the justice that authored the COCD Act, and he never revealed to Ed how to get out of it, which I find really funny now today. But the guy that authored it, he confessed to Ed saying that this was the worst material ever, and that's actually what caused him to retire. Now, I can't prove any of that. That's on the word of Ed. But Ed had some success with government. Like, he was really getting in good position, but I figured out that he was just under that special person. To issue that control person, like for Ez, he's already in that capacity, so he can close it, like, today if he wanted to.
I'm thinking so, yeah.
So he has to find the same equivalent act of the
hold on. Let's deal with that one little thing, because that thing with Ez, because a lot of us, whenever we're unsure of something, everything, if you notice, everything is all these acts. I always have a stipulation that you can always petition the minister for a determination on something. It just has to be written, right? And it has to be written with the information required to make the determination, right? So what I suggest is that instead of us jumping the gun, right? What I think Ez should do is Ez should write up and get a determination of that. Call the people and ask them.
Well, yeah, I think you're right. But, when I went to get the determination from this, well, I'm going to call it a determination, but basically it was an authentication of a person's act, an officer's act. They flat out refused. And I said, how can you refuse? This is one of your officers in your company. And
no, that's not what I'm talking about, Ez. What I mean is that office, all you need to do is it just needs to be one sentence.
I disagree, though, because he already did it. He's already got the opinion of the minister. They gave him the position.
Okay, but but what I'm getting at is that if he sends them a letter, right? Because don't call. It has to be a letter, so it's done on paper, right? Because if he gets them a reply stating that, right, then he's home free. And if they're going to dispute it, right, now he's already starting his fact of law, right, to deal with the matter in court. Right, because he's got this, and he can even state, I have this, and to me this, right, and from my understanding,
confirmation.
That's right. I want confirmation of this because this is my right, and so on and so forth, and I want a confirmation under seal from you.
But that's what I was trying to say. Is I tried to get a confirmation of the seal of a lower office from a higher office, from the actual secretary, or what I knew, the keeper of secrets, and they were going to authenticate hers, and they would not do it. And they told me we aren't doing it because we could lose our jobs.
Get that but didn't do it on paper, did you?
Oh, yeah, you make an application to get it done in the office. In other words, you have to make an application for them to do this, and they charge you money.
Yeah, so then they got to give you a written determination in return. Did you get them saying that they won't do that?
They didn't give me a written determination. They simply said, we can't do that for you. And I said, we had this big go around, and that's when the police came in the office and everything. And I said, you can't say that you can't, authenticate this person.
Okay, right there, that's telling me that you didn't do it by mail. You're trying to get into a pissing match in an office, right? And that's what the paperwork and us doing this stuff at arm's length is about. It's to make sure that we can't use all this stuff by us going in there and fighting with them. We can't use that in court. And it's just making us look bad because we're trying to go and do something that because we can't justify it.
I understand what you're saying, but I purposely didn't do it through the mail in this particular situation. And we're not talking about exactly the same thing. But anyway, I didn't purposely do it through the mail because with such a valuable piece of paper, this paper was at the time $110 million and, another authentication. But I figured all they had to do was
let's deal with that for a second because you're going to have to deal with that too. So what do you do when you have documents that are worth value that you can't actually give to other people? You take it to a lawyer or one of those guys called notary, and you get a certified copy, and you send the certified copy. And you tell them, I have the original for verification if you want it, right? And blah, blah, blah. But the point is that we have to start doing this stuff on paper. We have to just only deal with the determining factors and not let them keep us getting into this shit. So when you ask for determination, they send you back something like, we can't do that. Okay, well then you're going to give me a determination of why you can't determine it.
Can I interject here for a moment? Just on my experience with dealing with bills of equity and so forth, that first thing that was a priority on the paperwork itself was to put on the left-hand side, written from top to bottom, special private priority. This put this into their hands, being that it's, it's not, you're not in the public at that moment. It's not shared, and it's only between the two parties. And then you set up an appointment with who that individual who you want to go and speak the matter to, and therefore you're dealing in personam, which then they understand who you are, and you understand how they can deal with you. But if you go in there in the public and start talking, they're going to ignore you because they can't speak about it, among the parties, among the people around them.
Okay, can I ask a question, David?
Yeah.
Did you actually read that in an actual law book anywhere?
I took it through my own experience and experience of others when I was dealing with, Rourke and who else is that? Eric von Phelps and such, where I've done this in court, where it was, and it's happened to me, a day before the court date, and I wanted an adjournment. And when I talked to the lady on the Monday morning, whoever's at the front desk troll, said, "Are you kidding? You wanted an adjournment for tomorrow? There's no way. You guys put in front of a judge. Get out of here. Don't even bother. Those kind of things. You're way too late." And I said, "You know what? Just give me the form that I need to fill out for this." And she said, "Okay, well, here's where you go." So I did that. And by 12 noon that same day, I sent it in via fax with that special private priority on there. I forget what I put across the top, and I will remember when I look back into the notes. But 15 minutes later, I had a call from the JP and said, "Yes, how can we help you?" And I told him, "Well, I want adjournment." She said, "Okay, we'll get to the front of the judge right now. Can you be ready on the phone and whatever?" And I said, "Yep." And it happened. It expedited because it went into a different, I guess in their world, a different jurisdiction as in a private matter, because you're not dealing in the public anymore, and a JP can deal on both sides, right?
Well,
it's a clerk in the U.S., but in Canada it's a JP.
That will still be in the public, but you're finding an administration of law area that could be very helpful. So if any information that you have on that kind of stuff, that's really what we really need to. That's probably where we're going to end up really going into next, is into the deep administration of law process, right? Right. You see what I'm getting at? How to fast track things through certain processes, because those things are all available. They just don't, like the administration of law. You're going to find that it's one of the hardest things to find. I have a feeling that most of us are going to have to sit in the library, because that's pretty much the only place I've ever been able to study the administration of law, is when I actually go to the university law libraries, and actually, because the administration of law process is currently happening right now, and those books that they want are like $400 or $500 a crack, right? And they're still under trademark. So we won't find them in PDF on the internet, if you kind of see it. So,
sure. If I could come in for a moment, surely we've got to be a little bit more careful than this. I mean, don't get me wrong, I'm kind of a newcomer here, and you guys have been at this a lot longer than me, but I'm new to the group, and I don't want to cause any issues here. But in our own capacity, we've all studied in our own right, and I put a lot of time into this. I do tend to trust my intuition a lot. If it doesn't rest right, doesn't feel right, shouldn't kind of be doing it. And there are certain kind of rules I've created for myself. One of them is this clear distinction between what is public and what is private. Anything that exists out there in the public is going to turn you back into the public at every point, surely. My concern is, if we take it down to its most simple level, if you're interacting with their public, you are perceived as the trustee, and the trustee always pays. The trustee is the one that is in the system, and they're doing administrative law on the trustee. Sorry to oversimplify this. I think you've got to be really, really careful who you're talking to, who you're showing your hand to, right? And let's be honest, the biggest problem we have here in the UK is they confront us with their own ignorance. In other words, we end up knowing tons more than they ever do, and they can't get past that. They will always block you by using ignorance. We don't understand it. We don't know. I mean, this is the guy that went into court and tried to make the judge a trustee. And see how far that got me. I mean, that was a long time ago, but it was fun. So I'm just saying.
I did it too.
Yeah, from the teachings a while back, from people who I did respect, and this is going back 10, 12 years ago, I feel as if, where did I go for 10 or 12 years when I've come right back to what was first shown to me all that time ago, yet I was not able to comprehend or understand it. Do you follow me? So everything that's happened over the last 10 or 12 years has just brought me full circle. But now I understand, whereas before I didn't. And some of the rules, some of the things that were taught to us then were quite important now. One of which is, in the old way of doing things, you would auriculate. In other words, you would speak. And the way that they captured everybody, and I'm making this overly simple at the moment, is they would memorialize things, because everything they created a paperclip society, and paper could be interfered with, but the auricular could not. And that's how part of this whole public world was created, in terms of the manipulation that went on. So I think we've got to stand back sometimes and just look at the bigger picture in terms of who we're trying to interact with, which game we're in. Here we have a form called Form 206, Proof of Life. It's one of a set of forms that start, I think, at 204. Lawrence will probably correct me on this, and there's about 8 of them. And the form says, and it's in the Chancery Division, and it says that it's a proof of life in order that you be granted your annuity. Now, we understand that there's an exemption account. We didn't put the original startup capital, shall we call it, into that exemption account, but we have provided the energy by which the account grew. So we're entitled to the interest, therefore, or you might turn around and say a share of UK PLC, because it's just a corporation. Yeah.
This private and public thing, we've already have all of that in law. We can show you all that information in law.
Okay.
What happened they created corporations in 1285.
Yeah.
And it's all been corporations since then. So everything is basically a trust inside a trust.
Yeah.
There is no private inside English law in the private that you're referring to, as in a true private jurisdiction where no one has jurisdiction over you. You can't be in English law if you want to be in your own true private jurisdiction. Jurisdiction is based on your domicile and whether you own those lands or not. By you becoming the corporate person, you've given acceptance to a land tenure that your parents granted at birth.
Correct. I understand that. Yes.
So there's only 3 jurisdictions. There's 2 in English law, and there's natural law outside of English law, right? Not the law of nature, but natural law. Inside English law, there's even the monarchy itself only has a use for a fee. So the assumption in common law is that the monarchy owns the lands. But then the monarchy created all corporations, right? Starting in 1285, and then she created the trading companies and this statute of use jurisdiction that we're in now. That's the modern land tenure, right? And that's where the issue comes in, is that they created a corporation now. So before you basically swore directly to the monarchy, Now the monarchy has nothing to do with this. We volunteered to the corporation as acceptance of that land tenure granted to the monarchy. So the monarchy actually has nothing to do with the corporate person or the corporate shares or any of that stuff, because those are all a part of the incorporeal hereditaments, which is only a use for a fee that was granted by the monarchy to a juristic unit. So what we were going over with the Canadian Ownership Determination Act is that's just the corporate person and the shares of that of that individual joining the corporation. Because you're A and you granted the land tenure, right? You're actually taking those things back in trust, because government can't take things, they take it by law, and then they grant those things, right, in trust to, well, by a license, right? And because you're the next entity in line that has the capacity to actually take things in trust, you become the trustee, right, for your own things in reality, right? So by you joining the corporation, you get the citizens have to cut the trees, dig the ground, right, and all those things that citizens do are actually unlawful and against the land tenure. So they had to make a new jurisdiction to make that legal, right? So that's where a lot of the confusion comes from. And inside this equity also has private and public, right? But the private is still part of the group, so that group still controls it, right? So as soon as anybody joins a group, they become one in law with that group.
Yes, I understand that.
So they're bound by it. But what determines that group is the territorial boundaries. So when you remove yourself from that jurisdiction, your natural rights are life, liberty, and land. And English law doesn't own anything. All the lands in fee simple are in abeyance. They're not owned because there's no one alive to own them, right? And everybody in fee simple has descended in title to be guardians to the donors.
Yes, so understand that,
right? So that's what gives us our right to vest our estate and take back lands that we claim. Right? So
the point you're discussing now, are you, it's all a question of competency and capacity, is it not? What capacity you are operating in and how competent are you? I was just a bit confused because I must admit I did join the call a bit late, and I couldn't understand why you were looking at basically Canadian documentation, believing that you were coming at this, from a different angles, but you're actually looking at it from a statutory perspective, are you?
Well, that's kind of the catch about law, right?
It is, isn't it?
Pardon me?
It is, rather, isn't it?
No, okay, but you're not. But that's what everybody actually thinks. Everybody's bound to their own law, right? So if you're not in English law, you're bound to your law. So that means English law does not apply to you. So what happens if somebody in English law injures you? You can't take them out of their jurisdiction and force them to be bound by your laws, right? So if somebody in English law injured you, you have to find an English law, right, that shows that, right, that gives you the right to say that he's injured you, and find the remedy to get remedy from that person in their jurisdiction that injured you. Otherwise, we're not talking about law, we're talking about slavery, right? You see what I'm getting at? Law works both ways. It can't just work one way just because somebody wants something, right? So that's the biggest catch-22 that everybody's thinking right off the hop, is that I can take you to pull you out of your jurisdiction and pull you into mine and force you to abide by my law. That's not how this is happening, right?
I've always been aware of that. I mean, if a Chinaman came to this country as a visitor and is speeding up the motorway, the best the police can do is warn him of the local law and tell it, and send him on his way.
Okay, but why? But does the local law apply to the guy that's?
No, that's what I mean. They've got no jurisdiction over him, really.
No,
I mean,
but that they do because it's an equitable agreement. All the countries within the UN have all signed interjurisdictional agreements to make everybody in fee simple. So what that means is you're not only bound by your law when you go to another country, you're bound by their law as well.
Of course. Yeah, I realise that. I was oversimplifying it, but yeah.
Yeah, I just wanted to clarify that. So when you're not in English law, right? If I go into an English law territory, right, and I didn't establish with them, right, that I'm not within their jurisdiction, they're going to assume that as soon as I go in there because they assume that everybody within their territory is under their jurisdiction. So that's why these confirmations and things are done, and that's why we have to understand the laws of the jurisdiction that you're going into before you even go into them. So that's why the saying is, when Rome has, you have to go to Rome to get what Rome's got, right? What Rome is holding trust, you have to go to Rome to get, right? So that's the point here, is English law is holding all this stuff in trust for you, and they're not even allowed to hold it for you, and their law proves it. So because we can show by their own law that they can't do this stuff, we are showing something that is not only justifiable, it's recognizable, and they have to do it. Because that's how law works. Everybody's bound by their own law, by their own jurisdiction. And that's the one thing that everybody has to really understand this part, because that's just the rule of thumb. It's called finding the seat in law. And this is why a judge, the first thing, anytime anybody challenges jurisdiction in a court, the two things that he asks, and he only asks two things: where do you live and what do you do for a living?
Yeah, that's right.
Okay? And that's all he needs, right? Because that tells him the jurisdiction that you're in and the capacity that you're in within that jurisdiction.
So he forms a contract.
No, it doesn't form a contract. It does. It tells him what laws that you're bound by.
Okay, yeah, I'll accept that. Yeah.
Okay, so here's another example. If somebody in English law enters me and I'm not in English law, I have to go to their jurisdiction and make a claim. In that claim, I state that I'm not in their jurisdiction, right? And this is my capacity within my jurisdiction. So now the judge knows that no matter what in that trial, he can never enforce any laws on me whatsoever, because for one, he's not a judge of my jurisdiction. So he can't make law. He can't make a determination against me with my own laws, right? He can only make the determination against the individuals that he has jurisdiction for, that are within his jurisdiction, right? So that's why at the very beginning of any claim, they even ask you, where do you live and what do you do for a living, and all these things that you have to put on right at the very beginning of the form, right? It's a fill in the blank for that stuff. Right? And people always get it wrong, and that's why they lose jurisdiction by filing what they put in. The first sentence on these people's claims makes it vexatious, because people don't understand what divorced is and what the agreement is and how to get out of it, right? And it's these different capacities within these jurisdictions, right, that people get confused about, and that's why, like, a lot of the people that are in this room, they've researched a lot of the early law, and they got a lot better of idea how many different capacities there were throughout the beginning of English law, and now how they're all only fee simple, right? How all of those different capacities got wrapped into fee simple, right? And now everything's done just by that, because just by
Lawrence, can you mute? Lawrence, mute your microphone a minute, mate.
Just by having that there, right, ends up giving all the proof that they need. So
okay, I think probably what would help me, and it's a bit of an indulgence really, because I don't want to upset the timescale for everybody else and the flow of the discussion, is I need to get back to the steps in which we're doing this. I mean, you know, as I mentioned on a couple of occasions, the thing I hold most central to all of this, my rock, as it were, my anchor point, is remitter. We've looked at estates, we've looked at all sorts of different things, you know, but I always keep coming back to remitter from Black's 3, because to me, looking at that and reading that very carefully should show us the roadmap to what we're trying to do here. But I appreciate it probably is not that simple in terms of, you know, making that claim. So I was actually going to suggest at some point, if it's an appropriate time somewhere, for somebody to just give us a kind of roadmap, a steps guide to how this, so we can visualize how this may unfold, how the process might work. What step 1, step 2, step 3, so we know the order and we know what capacity we're in for each of those steps. It would help me a lot personally.
Nigel, I think if you just go back and listen to the beginning of this recording, you'll have those questions answered.
Okay, thank you. I'll just say my apologies. I did join a bit late.
Oh, that's no worries. We don't want anybody to be worried about jumping in at all at any time. I always feel free to. There's never any bad questions or anything, because what you don't know right now or didn't hear before, somebody else needs to hear it as well too. So it's not.
I often say that, you know, somebody might. There's no such thing as a daft question, because you're just brave enough to voice it, but 20 other people are wishing they had.
That's exactly it. That's exactly it, and that's why we need people to really. And that's what this is about: is standing up and because that's how we got into these agreements, by not understanding it all and still going through with it instead of pulling up reins and saying, no, you got to tell me everything about this agreement until I understand every tiny bit of it, or you're not getting it. Well, right? Because that's how we go. Right? Because
equity doesn't aid a volunteer. Look how we have volunteer for everything. Because most of the time we're too spineless to do anything else.
Okay, that is also completely wrong. Equity does aid a volunteer.
Yeah. So why is the maxim written that way?
What are you talking about, the maximum?
Well, there are 19 maxims of equity, one of which is equity doesn't aid a volunteer. I mean, I used to think the remedy was in equity and spent a lot of time looking at equity. I've even got Charles Viner's posthumous 12th sitting here, original hand printed. I mean, I'm that serious about it. God knows what it might be worth. It all depends on who would see a value in it.
Okay, hold on a second. Let's just deal with that. Equity does not
aid a volunteer.
Yeah. You got to realize that the one in equity isn't the owner. So if you're going to go and run up to somebody and say, hey, I'll help you do that, and you break their arm, well, guess what? You had no right to go over there and help them in the beginning, and now you injured that person. You see what I'm getting at? So
yeah.
That's the way that's what they're talking about by equity does not aid a volunteer, right? Now, if I go and volunteer and you're like, yeah, okay, yeah, I'll accept that, right? And
then you get injured, right?
No. And I say, hey, and if anything happens, I'll make sure that I pay your hospital bill or anything else, right? Then that right? Because he has to make that agreement. This is not, you went and volunteered. So if you go and bust your leg and he doesn't say, hey, I'll pay you if anything happens until you, right? Because I really need your help that bad, right? Even though you volunteered over there, right? You see what I'm getting at? There has to be
it's all about how you interpret it. Yeah. Okay.
Only governments can make one-sided agreements because you agreed to join the group. Whenever two individuals meet each other, that's the private that they're talking about within the equity, where just because you volunteered and broke your arm, now he doesn't have to pay you because you volunteered and he didn't say he was going to pay you, right? But if he did say that he's going to pay you and you do, right, if you get hurt, then he'll have to pay you because he made an agreement. Now that's a law, right? Your agreements are your law, right? Accepting that agreement gives it jurisdiction.
Okay.
So and this carries on with everything that we do, right? And so if we remember that each one of these things is a sphere inside a sphere, right? So equity is inside common law, right? Corporations each corporation is its own little bubble inside equity, right? So now there's a million bubbles inside one bubble of equity, right? And inside one of those millions of bubbles, there's the juristic unit. Then inside that juristic unit, there's another million bubbles that have a bunch of different class of subjects, which each bubble of those are a different class of subject depending on what agreements you made, right? And they all fall within that bubble that falls within that other bubble that falls within that other bubble. You see what I'm getting at? And it continues on. Everybody's ignoring all those bubbles and different levels of bubbles and all those spheres, and they're thinking that the sphere that they're in as a citizen is the biggest bubble, and everything is inside it. Well, that's completely backwards. Because they joined the group, they're at the either inside the very smallest bubble within all those bubbles that you'll need a microscope to see, right? Or you could look at it as being at the very bottom of the ladder, right? Or at the very bottom of the well, where you're sucking off the bottom because there's nothing else below you, right? That's a citizen. It's the lowest form of entity on this planet.
Yeah, I get that.
And
Common stock.
Villain.
And that's right, a villain. You're actually right. You're not even above ground at all, right? You're almost in the center of the planet. You have
hence the expression we're the foundations of society, because we're below the ground. Yeah, we're in the foundations.
So everything in reversion that we're talking about, and everything that this group is about capacities and law. How to move yourself from one bubble to the biggest bubble, right? From that little tiny bubble, because that's the thing. The citizen can only be that tiny, tiny, tiny little bubble inside all those bubbles, right? Or you can be the big bubble on the very outside. You only have those two choices. You're either all the way inside the group and right to the center of that core, right? Or you're outside in your own universe.
Well,
right? You're not even on that planet, and you control everybody. You control everything on that planet because they chose to descend themselves in capacity and law to all those above them. Does that kind of help?
Yes, it does. Wow.
So that's really what we're dealing with is capacities. We're not dealing in any titles or anything else because titles are only in English law. As soon as they start talking titles, you know they're talking equity, and that's not where you want to be.
Correct. I know. Right? I don't want to be in equity. That was that was an excursion that initially felt as if it was going to be very promising till I woke up to the fact that that's not where we want to be, as you rightfully say. Yeah. But for a while, it was, it seemed to be a good direction to go in. There's just so much information out there, William. It's really easy to get sidetracked and go down what we call a cheeseless tunnel, you know?
Oh, we totally agree, and that's why we started Omnipotence, and that's why the sources on Omnipotence are to make sure that you don't have to go searching down all those rabbit holes. All the important information is all here. We have all the acts, all the books for all the different areas of law to give not only the basic understanding, but to take you right to the very original sources of every area of law. It's all explained it's all not only explained, but defined as far as it can be defined in law. Can
I just ask one more question, which is a bit of a burning question for me, if I may, just indulge me a moment longer.
Sure.
there is a widely held conception that as of the bankruptcy, Geneva Convention 1930, that they were looking for a way to turn this into a contract law society, and they did it through a very small case that actually rose to the Supreme Court in America. Everybody will know that that case is Tompkins v. Erie Railroad, whereby Tompkins was suing Erie Railroad for an injury. And it was determined that because he hadn't actually bought a ticket, he wasn't in contract with the railroad, so he couldn't sue them. The story goes that his shoulder was injured when a carriage door flew open. But irrespective of that, it was a principle. And from that point on, we were in a contract law society. Now, if we take it a step further, it's believed that all law was suspended. And then from that point on, there was only policy. And I just wonder what you guys thought of that concept and whether it's important. In other words, those that we're talking to or interacting with, maybe they're on a different story to the one we're on, and hence that may cause some confusion.
That's actually a myth. Every new jurisdiction that English law has ever made, the people inside that society, they don't even know that they went into a new jurisdiction.
Correct.
It just happens. So that's the reason why people believe that all this, right, that this went bankrupt and that went bankrupt. Well, yeah, it went bankrupt, and that part of that old corporation stopped existing, and you went to a new jurisdiction.
Yeah, 70, I believe, isn't it?
Well, no, they're all corporations.
Yeah.
Once all the shareholders of a corporation leave, the corporation's now bankrupt and closes. And everybody went to the new corporation. So people are thinking that it went belly up, but it didn't go belly up. They just went to a new company and they took everything with them.
Yeah, I get that. But we went from positive money into into debt. We became debt-based economies, did we not? So
you're talking about after the 1930s when they abolished the Gold Act, right?
Yeah.
Yeah. Okay. But how to help?
Well, there were bankruptcies prior to that, of course, but that's the prominent one, and they took all the gold away, so there was never the means to pay any debt.
Well, there is no debt.
No, exactly.
It's all fake. And now that
it's all a fiction. Yeah, exactly.
And removing the gold was just a logical step forward because it was something that attached them to the real world, the natural world. So getting rid of gold or any type of physical-based backing allowed them to grow the jurisdictions into further, deeper wells.
Yes. It was about removing substance. Yeah.
See, even that thing about that, all that gold and everything, and those bonds and all that crap, it's anything that's a natural resource, gold and everything else. Everybody that's in English law, they don't have a right of ownership. So that's why all these... Pardon?
No, I would agree. Yeah. No, nobody has a right to own anything. I mean, the Red Indians knew that, didn't they? They were just custodians of it all. It was the British who suddenly decided if they wandered up a beach and said, who claims this land?
Well, wait, the control person has the right.
Yeah,
the control person does.
Yeah. Have you read any law of domicile or private international law?
A little bit, yes.
I've read it all.
I think that's really where you need to start.
Okay.
Because English law started in 1066.
I understand that.
Anytime that anybody that's in fee simple, they don't have the right of ownership. So everything that all the lands that they go and inhabit, because they can't own them, right? They take the assumption of ownership, and that goes to the monarchy. And the monarchy grants a use for a fee to the governments, which give a title by purchase to the citizens in fee simple for their own natural right that they granted to the monarchy. See what I'm getting at? So
Yep.
they're not allowed to own anything. The natural resources they're not allowed to have. So the Gold Act and all these other things happened because the fee simple were abusing the laws, and they were usurping the true owner's inheritance. Right? So all these people that are saying that they're going to claim all the gold back for the people and all this stuff, that's the biggest crock of shit you'll ever hear.
Fully
These-
understood. No,
Right?
I have no issues with that. No, I do get all that. You know,
see
you've
what
got to be
I'm saying?
realistic.
So if anything, that the
So
Va-
what's
the
the
Vatican
accurate
and
way of describing what the control person is, though, to the trust? Because is that not our right to the ownership of the share of the corporation?
of the corporation, that's right. But then you're also the control person of the land tenure. So in reality, there should be an interest, like there should be a same accounting as the Canadian Ownership and Control Determination Act, because you're getting a percentage of that whole corporation because you join that group and everybody inside that group gives everything equally and gets the same profit in return, right? That's what the Canadian Ownership Determination Act is about.
So the back of the
So-
birth certificate, that red number, that's going to be the control person accounting's number.
That's right.
Right,
And
okay.
if we look at the same thing for the land tenure, because everybody within English law, they all have to give the lands and throw it all into the pot, just the same thing as the corporate person does. Right? See what I'm getting at? So all the so because it's all one group, and we've all thrown it all into the pot, if they go and take 20,000 tons of gold out of the entire history of English law from Alaska, everybody within English law is going to get a percentage. There should be accounting already set up through the Canadian Ownership Determination Act, and what the government's doing with your corporate person accounting is all going to be linked to what I suspect is to another accounting thing, right? So you can get all the real natural resources from the entire group for the land tenure. And that's why I believe that they abolished the Gold Act. That's why there's not going to be any gold in the vaults like they say in the United States or anywhere else. It's all in a mountain somewhere with all the other massive amounts of valuable natural resources that these people are not allowed to have.
I go along with that. Yeah. They moved all the gold from the Twin Towers, didn't they?
Yes,
all
from
the
everything.
cover up to move the gold. Yeah.
Exactly. But they had to do that for the people, right? You see what I'm getting at? You kind of see where I'm getting at, right? They're just making the belief of the people change, while the law does something else.
Oh boy, yeah. Is that so true? Yeah.
And
That's the big deception. Yeah.
and you'll
We
notice
consume the gold. The gold that they had in reserves is in our consumer products now.
Yes, exactly.
It's consumed.
Yeah. Yeah.
Got to remember that they can't go
Tablet.
past what they have in law, so they just mirror what's written in law.
That's right. And if anybody watches National Treasure after reading all this stuff and everything, and if you guys have been researching Montesquieu and the corporations and stuff like that, especially after that professor from Cambridge videos, I think you guys are going to be amazed when you find out what Montesquieu and those guys had to actually do with all this stuff. It's going to blow your mind away how deep this is actually going to go.
Yeah.
And where this takes everything, and the truth is in the law. If you want to find the truth to anything that's ever happened in history, you will find it in the law. It's all there. I can't even scratch the surface on the things that I've read. It would blow people's minds. and that's why we're putting the stuff on the site and having these meetings and getting people, because it's more the getting the understanding of what your rights are and what the system is. Once you have that understanding on what English law says that stuff is, you'll be ready to vest, because equity has indoctrinated everybody into believing the opposite of what's actually true for your real natural rights. And once people actually understand that, that's all that's actually holding you back, because the information's there and it's really not that complicated. I guess we should, because I'm sure everybody wants to do a quick thing on maybe the courts again and that stuff, or does that sound good?
Yeah.
What do you guys want to talk about? Because we can get into something like that too, and it would help a lot too, I think.
Yeah, I'm happy to go with the flow. Yeah.
If we're going to do that, we should start another call. I think we have a different subject.
Yeah, well,
It's up to you guys. If you think it goes together, it's fine. I don't care.
yeah, Justin, press pause and
I can just stop it and start a new one, yeah?
yeah.
Yeah, that's all you got to do. We don't have to hang